Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal educational content, and today may be the day I earn your subscription. For today's content, we have a panoply of stories, a potpourri, a chef's selection of stories for you. Yes, it's Jussie Smollett, the famous French actor, Josh Duggar, QAnon shaman Jacob Chansley, and Alex Murdaugh are topics for tonight. There is so much happening in law all over the place, and we have to choose which stories to cover because, man, oh man, there is just so much happening, and it's just impossible to keep up with it all. Maybe people could stop breaking the law for a while or something. I don't know. But in any case, we're going to be covering these stories. We'll spend a little time on QAnon shaman guy because his case is stupid. But let's get started right away with our friend Jussie Smollett, who is a famous actor on the show Empire. So on the stand so far, we've had we initially had the initial opening and the initial close from the prosecutors and from the defense lawyers. So we had the opening and the close. So I'll give you a little bit about what's going on there first. So before we talk about the actual trial part. So first of all, we have the prosecutors arguing during their opening that this is a fake hate crime. Nothing we didn't know before. During the opening arguments, the special prosecutor uses the word fake over and over and over to kind of drill the point home through the prosecutor. And that they gave a false report to the police on 6 different occasions, which leads to 6 different felonies. So we have 6 independent occasions on that. All right, so we know the prosecutor's theory of the crime, right? Jussie Smollett faked it. So what is the defendant's theory of the crime? Well, the defense theory of the crime, which probably doesn't shock anyone, is that Jussie is the real victim of the attack in Chicago. Yeah, Jussie Smollett is still claiming this is a thing that really happened. He is still claiming that, you know, at 2:30 in the morning during a not just a blizzard, but there was like a special freeze warning or something, or because of high winds. It was high winds and freezing, so there's like some special warning. So at 2:30 in the morning, according to Jussie over here, when it's like 30 below and the winds are just blowing through Chicago, because I don't know if you know that it's windy in Chicago. It's windy in Chicago, the windy city. Sometimes it's windy in Chicago. Yeah, so it was windy and cold. So at 2:30 in the morning, according to Jussie over here, he decides to leave his apartment to go to Subway, and in the course of that, he is accosted by 2 white men wearing MAGA hats who just so happen to have bleach on them, just so happen to have a noose on him, said, "You're that effing enter from that show Empire," and then put a noose on him and threw bleach on him. This is the worst unfortunate timing of all time. What are the odds, my friend? What are the odds that during this polar vortex, that was the words I was looking for earlier, what are the odds that during this polar vortex, Jussie over here would just happen to go out with 2 other people who are also braving the polar vortex, who had MAGA hats, who also happened to have bleach and a rope on them at the time, and were able to get hold of this person who is the embodiment of everything they hate, the F and the N thing. What are the odds? Not that great, my friend, not that great. So before we move on, though, Stephanie has reminded me I need to make a few announcements to the channel because, hey, why not? Let's make some announcements to the channel. So first of all, we want to say thank you, everybody, for all the looks that we're getting here. We're really pleased with the uptick in subscriber count. If you have any questions, as always, tag Stephanie. She's our head mod. And if we hit 50,000 subs before the end of the year, we'll have a special celebration. So when we hit 50,000, we'll have a celebration. But if we do it before the end of the year, we'll have a special celebration. I don't know what that is. We'll figure out something. So if we hit 50,000 before the end of the year, we'll have a special celebration. And those are just the ground rules for the new people. Remember to be nice. Remember to remain vaguely on topic. And make sure to subscribe so we can hit that 50,000 goal and help this thing grow. So to all the people who have been helping the thing grow, thank you so very, very much. All right, so let's get a little bit back to our story now. Jussie here is the real victim. He's the real victim of a real hate attack that really happened, really in Chicago, when it was really cold and really windy in a real polar vortex, with real white people, with real MAGA hats, with real rope and real bleach. This is the worst confluence of events ever. The defense attorney said that the two people attacked Smollett because they didn't like him. And that and the $3,500 check that he paid to the brothers was for training so he could prepare for an upcoming music video. The defense attorney also suggests a third attacker was involved and told jury there's not a shred of physical and forensic evidence linking Smollett to the crimes police allege. Well, I would disagree with that. There is physical evidence. The rope is a piece of physical evidence, right? The rope that he had around his neck. Incidentally, when he was walking through the streets of Chicago on the way back, and I think the news article covers this, when he was going through the streets of Chicago because he was caught on a surveillance camera, he had the rope over his shoulder, not around his neck. But when he walks into his apartment, suddenly it's around his neck. How funny. What a coincidence. So there is some physical evidence. The bleach on his clothes, the rope around his neck, that last time I checked qualifies as physical evidence. So there's that. Hate to disagree with your prosecutor, defense attorney on that one. Jussie is the real victim. Sure he is. That sounds definitely plausible. So the prosecutor has told jurors that Smollett was unhappy about how the studio handled a letter he received. So, yeah. So this is like a different incident entirely, which has also been potentially linked to Jussie because it also has its own suspicious circumstances. So a letter arrives at the studio for Empire, addressed to Jussie, right? This letter arrives addressed to Jussie. This is entirely separate. And in this letter, it apparently is making all kinds of threats and stick hanging from a tree in MAGA, right? This letter that arrived just before the event, and Jussie says, "Oh, I was, so I was unhappy about how you handled that letter, so I staged the attack." He might have also staged the letter. So I don't know where, if at all, the FBI, U.S. Postal Service, or U.S. Attorney are in on that, because lest I remind you, mail fraud is a federal crime. It faces up to 10 years in prison. So don't commit the mail fraud. The prosecutor says Smollett concocted the attack and that he had a dress rehearsal with the two brothers who worked on the Empire set, including telling them to shout the racial and homophobic slurs at MAGA. He also told them to buy ski masks, red hats, and a rope. He told them to use the rope to make it look like a hate crime, according to the prosecutor. But the prosecutor also points out that Smollett turned down extra security when the studio offered it. So it's not that the studio did nothing. The studio offered extra security. I think Smollett might have been hoping for a raise. Or I apologize, the defense attorney said that, which doesn't sound that great because, and the brothers that are involved in this might be unreliable. And then this article says something that kind of annoys me, because midway in this article, it just says whether Smollett, who's black and gay, will testify remains an open question. Why do we need to mention the fact he's black and gay in the middle of this article? These facts are not relevant to the crime. Why are we mentioning this, Fox News? Just a small note of annoyance from me personally. But that's a little bit what's happening. Let's talk a little bit more about what's happening now on the stand, that we're on to day 2 of this thing. So now we have a detective starts the prosecution's case. So this guy, Michael Thies, I guess. So he was a detective at the time, now an assistant director for research and development for Chicago. Said the department had 24 detectives clocking 3,000 hours on this crime, and that they thought it was a real crime at first and only later discovered not so much. And everyone wanted it solved, you know? So yeah, at the time it was huge political news for those of you who remember. You know, everyone was popping off about this huge, horrendous hate crime and anti-black this and anti-gay this. And it's like, oh, no, not really. So yeah, the investigators checked out the brother's account, including that the actor picked them up days before the attack and drove them around the downtown neighborhood where he lived and talked about what would happen. So we gave him a preview of the neighborhood. And he corroborated the events using GPS cell phone records and video of it. So we have records that corroborate that these brothers were in the neighborhood. The trainers were in the neighborhood in the days advance. So we have records that validate that thing occurred. So we have some forensic evidence, right? So the jurors have also been shown a surveillance video of the brothers buying supplies, including a red hat they told Smollett wanted them to wear to resemble supporters of President Donald Trump. They couldn't find actual MAGA hats, so they just had to find a red hat and a piece of clothesline police said was fashioned into a noose. They saw a still image from a video the police officer said Smollett of returning home that night with the clothesline draped around his shoulders. The clothesline was then wrapped around his neck when the officers arrived. How funny and how coincidental is that? So yeah, that's all the things going on. That's all the things going on. The defense attorneys suggest the brothers are homophobic, asking them a cross-examination about a homophobic brother word the one of the brothers used. And the defense attorney is also trying to discredit that paying them by check makes no sense, because it was the memo says nutrition and training, so that's definitely what it was for. So all those things are what's going on in Jussie Smollett land. So yeah, you know, so one of two things is possible. He's a victim of an actual attack by these actual people who just happen to know he'd be out on the street at 2:30 in the morning and during a polar vortex when it's 30 below and windy outside, and just happened to have the bleach, and they were lying in wait for him in the snow on the off chance that he might come out and walk in that particular direction, as opposed to, for example, having one of his people do it for him, or ordering in, or heating up a pizza from the freezer. I don't know. So either it's like the most coincidental timing ever, or the whole thing is made up. So I'm kind of thinking the whole thing was made up. I'm not buying this. All right, let's move on to story number 2. Josh Duggar trial is starting. So Josh Duggar is a bad man. He is a bad man accused of doing bad things. He is accused of doing many, many bad things with some CP. Yeah, it's not great. This is a star of a TV show, 19 Kids and Counting. Josh Duggar is starting his trial for the CP stuff. He made headlines in 2015 when news broke that he personally mistreated in a prurient way for a number of young girls, including his own sisters. So that's exciting. And now he's on charges for possessing these other crimes. And he's facing 20 years in prison and a whole bunch of fines. So, yeah. You know, the evidence is pretty good because the police have the photos. So I was like, well, here are the photos, which the jury then gets to see. How much do you want to be on that jury? That's got to be a fun jury to be at. Okay, I'm the prosecutor. I'm now going to show you some pictures of CP. Greatest jury duty ever. That's sarcastic for the YouTube people who don't have a sense of humor. You know, that's got to be a rough one, man. But yeah, they have the photos and they have the testimony, and it's not going over well for Josh Duggar. So I think federal prison is looking likely for you, my friends. So probably want to get real comfortable with that one. Yeah. So let's move on to story number 3. It's QAnon shaman guy. QAnon shaman guy is in the news. He is seeking to void his guilty plea. He pled guilty. He pled guilty and he was sentenced to 41 months in jail, which is, 3 years and change. So it's pretty significant. And he is represented by a new attorney, John Pierce, who represented Kyle Rittenhouse for a little while, who John Pierce is not exactly my first choice of a lawyer, to be honest, any more than like Lynn Wood or Rudy Giuliani. John Pierce is kind of not the person I'd recommend, although he might be the perfect attorney for this client, but whatever. So we're trying to appeal the sentence. So this appeal comes the day after the federal judge accepted his plea and sentenced him. So, there's that. So he's going to try to appeal he's appealing both the judgment and the sentence. So he wants to appeal the judgment of guilty in response to a guilty plea. And he wants to object to the sentence. Okay. So let's talk a little bit about what he did according to him, right? Because we're going to now review 2 documents. This will be the longest story of our day because we're actually going to do some legal analysis on this one. So in order to plead guilty in the federal system, it is almost ubiquitous that they're going to get you to sign off on a statement of facts. Like, here are the facts, you're agreeing to these facts, and also a plea deal, right? So you're signing off on the facts. These are facts. I agree to those facts. And you are also agreeing to the plea deal. So we can cover those things, right? We can cover those things and see, what did he agree to? What is the plea deal? Great, let's do that. All right, so here's the statement in support of the guilty plea. So this is prepared by the U.S. attorney, but he signs off on it. He signs off on it to say, yes, I agree to these things. So the defendant agrees to plead guilty and enter a guilty plea on count 2. The penalty for this offense, they stated right up front, the penalty for this offense is a term not greater than 20 years, a fine not to exceed $1 million, a term of supervised release up to 3 years, and a special assessment of $100. They spell it right out for you. Like, here, they put it right up front. Here's the possible penalty. The elements of the charged offense. The defendant corruptly obstructed, influenced, or impeded, or attempted to do an official proceeding. A proceeding before Congress is an official proceeding pursuant to 18 U.S.C. 1515, which, So, you tried to corruptly, with corrupt motive, obstruct, influence, or impede. The reason why it says corruptly, by the way, is because you can non-corruptly influence. That would be like if you're lobbying Congress or just giving testimony to Congress, right? You're trying to influence them, but not corruptly. So that's why the word corruptly is in there, because there are lawful methods of influencing an official proceeding. So that's why the word corruptly is in there, to have that additional thing. Okay. And the official proceeding is Congress. That's great. So the government respectfully submits the following statement of the offense in support of the guilty plea by the defendant, Jacob Chansley. If this case were to go to trial, the government would be able to prove the following facts beyond a reasonable doubt. So they're laying it out. What are the facts? The U.S. Capitol is secured 24 hours a day by Capitol Police. Restrictions around the U.S. Capitol include permanent and temporary security barriers and posts maintained by Capitol Police. Only authorized personnel with appropriate identification are allowed inside the U.S. Capitol. On January 6th, the exterior plaza was closed to members of the public. That's true. We saw huge gates around it with many, many signs. On January 6th, there was a joint session in Congress to certify the vote count. At this point, again, for the YouTube people, I'd like to point out that in describing this, I am in no way encouraging or suggesting that this is a good idea. I can't believe I have to explain this, but apparently I do. In describing this, I am not saying that you should go do these things. These are bad things to do. Do not do these things. If you do these things, you may get these penalties. I can't believe I have to explain this to YouTube. Unbelievable. As these proceedings continue in both House and Senate, with Vice President Pence providing a large crowd gathering over the U.S. Capitol, by 1:50 p.m., the defendant, Jacob Chansley, was among the members of the crowd at the police line, where the U.S. Capitol Police and Metropolitan Police were standing behind the line. Defendant was dressed in a Viking hat with the fur and horns, was shirtless, wearing red, white, blue face paint, and carrying an American flag tied to a pole with a sharp object at the tip and a bullhorn. At 2 p.m., certain individuals in the crowd forced their way up, through, and over the barricades. The crowd was not authorized to enter. The defendant was among this crowd that passed the police line, entering the scaffolding. Defendant and others pushed past the police line at top of the scaffolding and entered the Upper West Terrace. At this time, certification proceedings were still underway. The exterior doors and windows were locked or secured. Members of the Capitol Police attempted to maintain order and keep the crowd from entering. However, after 2 p.m., individuals in the crowd forced their way into U.S. Capitol, including by breaking windows and assaulting members of the law enforcement. This riot resulted in substantial damage and requiring the expenditure of more than $1.4 million to repair. So that's a lot of damage, which, you know, I believe. That sounds very plausible. Because some of the stuff in the Capitol is fairly ornate. So depending on what you damage, yeah. Defendant was with this mob that went into the Senate side. Other members of the crowd broke in. Shortly thereafter, the members of they did evacuate the chamber. Defendant and other rioters ascended the stairs to the second floor. In clearing on the second floor, defendant and other rioters were met by a line of U.S. police officers, instructing them to leave. Defendant challenged the police officer, KR, to be let pass, also ultimately using his bullhorn to rile up the crowd and demand lawmakers be brought out. So he is fairly literally leading the charge. Instead of obeying these instructions, defendant traversed another staircase. At 2:52, defendant entered the gallery of the Senate alone. The defendant then proceeded to scream obscenities into the gallery while other rioters filled the floor. Defendant left the gallery and proceeded down a staircase in an attempt to gain entry. He therefore once again encountered Officer KR, who once again asked him to leave. Defendant insisted that others were all around the Senate floor and he was going to join them. Officer KR then followed the defendant onto the Senate floor. Defendant then scaled the Senate dais, taking the seat Vice President Mike Pence had occupied less than an hour before. The defendant proceeded to take pictures of himself on the dais and refused to vacate the seat when Officer KR, the lone law enforcement officer at the time, asked him to do so. Instead, the defendant said Mike Pence is an effing traitor and wrote a note on an available piece of paper saying it's only a matter of time, justice is coming. Well, you were right, my friend. You were right. Again, not an encouragement to engage in this. I'm just simply noting that quite literally it was a matter of time and quite literally justice did come. Not an encouragement to do these things. As Officer KR again asked the defendant vacate the seat, the defendant remained, calling up other rioters to the dais and leading them into an incantation. You should not do these things, which includes giving opportunity to allow us to send message to all the tyrants, communists, and globalists. That's our nation, not theirs. Will not allow America, the American way of the United States, to go down. Defendant went on to say, thank you for allowing the United States of America to be reborn. Thank you for allowing us to get rid of the communists, the globalists, and traitors within our government. Yeah. Eureka Hope says, what a threat. He wasn't charged with being a threat, Eureka. Please pay attention. That's why we're doing the legal analysis. Was he charged with being a threat? No. Well, he might have been, but that's not what he pled guilty to. So what he's charged with is kind of irrelevant at this point, because only what he pled guilty to is a conviction. He pled guilty to obstructing an official proceeding. So you say, what a threat. And I say, well, I don't care, because he was charged with obstructing an official proceeding. I think these recitation of facts lay out a pretty good case that he was, obstructing an official proceeding, which is the thing that he said that he did as part of his plea agreement. Yeah. As a result of these dangerous proceedings, Congress could not resume until every occupant left. In the days after, they gave media interviews to which the defendant said, okay, Stephanie. I'll stop with that. Stephanie is one of my mods, and she helps me behind the scenes, and I'm very, very thankful for her work as always. She's a fantastic mod and fantastic person, and she helps keep me on the straight and narrow. So her work is always appreciated. So thank you, Stephanie, for that kind reminder that maybe it got a little excessive. I sometimes do get out of control, but Stephanie's the greatest. The defendant actions halted normal functioning of Congress, including the certification. And this is signed, of course, by the U.S. attorney, and then most notably signed by the defendant, right? This is where the critical part comes of this exercise. This is where he signs it, saying, yes, that happened. I have read this factual proffer. A proffer, by the way, is just a very fancy term for like an off. It's also sometimes called an offer of proof. It's basically, here's what I would be offering. Here's what I would say. So I've read this factual proffer. I've read what you would be presenting. I understand it and agree it's true and accurate. So he agrees to it. He agrees to it, right? While this is not a complete recitation of what I did, of all that I did or all that I know, it represents some of my conduct and some of my knowledge concerning my own illegal involvement in activity. No threats have been made against me, nor am I under influence of anything that could impede my ability to understand this proffer fully. Signed, Jacob. So, right, that's the critical part. And then also co-signed by his attorney, where he just says, I've read it, reviewed it, and discussed it with my client to make sure that he's getting counsel, right? Right. So that's why the attorney signs off. It's like, I've also read it, I've reviewed it, I've discussed it with my client. He's gotten my legal advice. So the client reads it, says, yes, all these facts are true. Jacob says all those facts are true. So all those things happened as far as the law is concerned. And as far as the law is concerned, all those things happen. So, you know, because he conceded. It's like he signs, he agrees. What more do you want? He did all those things. All right, so now let's read the plea agreement. Let's read the plea agreement as well, because that will be helpful in understanding law. Now, the reason I want to go through this in a little bit of detail is because a plea agreement is a contract. It's just a special kind of contract, right? It has a special name called a plea agreement, but it's a contract. Right? And like any other contract, it's understood by its own terms and its own parameters. So what's in the contract matters. What's outside the contract doesn't matter, right? What matters is what's inside the contract, what's within the four corners of the contract, right? So when you're reviewing any contract, and this is no exception, you need to read it, understand it, and see what it does say and what it doesn't say, right? So let's see exactly what this contract says. What is exactly the nature of this plea agreement, right? It could say a whole bunch of things. It could potentially say any number of things, maybe infinitely many things, right? I mean, theoretically, there could be any nature of agreements, right? It could be a lot of different things. So, you know, hey, what did they agree to? Well, let's read it and see. All right. So this is addressed to Watkins, his attorney. This letter sets forth the full and complete plea offer, right? This plea offer expires on August 13th. If your client accepts the terms and conditions, please have your client execute. Upon the execute document, this letter will become the plea agreement. The terms of the offer are as follows. So full and complete. Full and complete. Magic words to an attorney. Magic words to an attorney. Full and complete. This is all there is. There's nothing more. This is all the things. That's what full and complete means. This is it. This is everything. This is all the things. Okay, so your client agrees to plead guilty. They wrote count 1 and then struck it out, wrote 2, which is fine. And then they initialed the change. So initial the change. In the indictment, charge your client with obstruction of official proceeding. Your client understands that a violation of this carries a maximum sentence of 20 years, a fine of $250,000 or twice the pecuniary gain or loss of the offense, a term of supervised release of not more than 3 years, and an obligation to pay any applicable interest or penalties on fines. This is exactly the same language we saw in the recitation of facts. It's like, we're not trying to hide the ball. In addition, your client agrees to pay a special assessment of $100 to the clerk of the court. Don't ask me why. That's just $100. Your client understands that pursuant to law of the United States sentencing guidelines, the court may also impose a fine that's sufficient to pay the federal government the cost of any imprisonment, term of supervised release, and period of probation. So they can fine you as much as it will cost to imprison you and release you and probation. They can fine you for all those things. That's a thing that you're agreeing to. Further, your client understands that your client has 2 or more convictions for a crime of violence or felony drug offense. Your client may be subject to substantially higher penalties provided for in career offender statutes and provisions of the sentencing guidelines, like we're trying to make all the things. Your client agrees to the attached statement of offense, fairly and accurately describes your client's actions and involvement in the offense to which your client is pleading guilty. Please have your client sign it and return the statement of offense as a written proffer of evidence along with this agreement. In consideration of your plea of guilty, this is what we are offering. This is what we are offering. In consideration of your plea of guilty to the above, your client will not be prosecuted further by this office for conduct set forth in the attachment of the offense. The government will request the court dismiss the remaining counts of the indictment, in this case at the time of sentencing. Your client agrees and acknowledges the charges are to be dismissed at the time of sentencing were based in fact. So you're agreeing those charges are not part of a malicious prosecution. You're agreeing that those charges, even the ones we're dropping, are in fact based in fact. So they're not just something we're conjuring, right? That's part of the agreement. After entry of this plea of guilty to the offenses identified above, your client will not be charged with any nonviolent criminal offense in violation of federal or District of Columbia law, which was committed within the District of Columbia by your client prior to the execution of this agreement, and about which this office was made aware by your client prior to the agreement. So, however, the United States expressly reserves the right to prosecute your client for any crime of violence, if in fact your client committed or commits such acts prior to or after the execution of the agreement. I froze. It looks okay on my end. Drop frames. Did I just freeze for a second? It looks okay on my end. Stephanie said my camera froze for a second, but it looks okay on my end. Anyways. So yeah, you're agreeing to all those things. We agree not to charge you for any nonviolent offense that you committed. We agree to drop all these charges. We agree to not charge you for any conduct that occurred in this, but we will prosecute you for any other violent offenses that are distinct. All right, so here's the sentencing guideline, right? Your client understands the sentence in this case will be determined by the court pursuant to these factors, including a consideration of the sentencing guidelines. So the sentence is to be set by the court pursuant to the federal rules of criminal procedure and to assist the court in determining. The parties agree to the following. All right, so here's what you're agreeing to. The parties agree the following sentencing guidelines apply. Base offense level 14. And it goes to cite how that's calculated. Special offense characteristic, injury property, 8. Special offense characteristic, substantial interference, 3. Total is 25, right? So total is 25 for this level of offense. And you're agreeing to that. The government agrees that a 2-level reduction will be appropriate pursuant to law. Provide your client clearly demonstrates acceptance of responsibility to the satisfaction of the government through the allocution, adherence to every provision of the agreement, and conduct between the entry of the plea and imposition of the sentence. So we'll agree to drop it from 25 to 23 if you satisfy us as part of your allocation. They're not trying to trick you, incidentally, here. They're really not. They just want you to actually, say exactly what you've already agreed to and not try to hide the ball. They're not trying to trick you here. It's like, yeah, if you are faithful to it, this is not a trick. They will definitely do it. Further, assuming your client has accepted responsibility as described, the government agrees that an additional 1 level will be appropriate pursuant to law because your client has assisted authorities by providing timely notice of your client's intention, thereby providing the government. So we'll provide you another drop down because you did this fast enough to save us the cost and time and expense of actually going to trial. So we'll drop it from 25 to 22. Nothing in this agreement limits the rights of the government to seek denial of adjustment for acceptance of responsibility and or imposition of adjustment for obstruction, regardless of any agreement, should your client move to withdraw the guilty plea after it's entered. So incidentally, that would be like now. So like, yeah. Or should it be determined by a government that clients either engage in conduct unknown to the government at the time that constitutes obstruction, or engage in additional criminal conduct after signing. So if you engage in additional conduct, that's before sentencing. So if you manage to commit more crimes between the time we reach this plea agreement and the time we reach sentencing, which is definitely a thing that sometimes happens. That's definitely sometime the thing that happens. So if you commit more crimes in that interim, we're gonna yank that away. So in accordance with the above, we estimate it will be at least 22. So based on this information, your client has no criminal convictions. Accordingly, your client is estimated to have 0 criminal history points, and your client's criminal history category is estimated to be level 1. So in the sentencing guidelines, there's 2 axes. There's 2 axes, and each axis forms a little box. So you come up with a box grid, right? So one of the axes is how bad is this offense, and they calculate points in various ways by statute and regulations. So how bad is this offense? And then how bad of a criminal are you in general? Like how many bad things have you done? The idea being, of course, if you've done more criminal things in your past, then so far it hasn't dissuaded you. So maybe we need to punish you harder. So yeah, you determine how bad this offense is and how bad you are in the past. So you are level 22, 1, because you haven't done anything bad before. Okay, now here's the critical part. Here's the critical part, right? Really critical part. Based on the offense level and the estimated criminal history category set forth, your client's estimated range is 41 to 51 months. The estimated range. So the Department of Justice is telling you they're not hiding the ball. They're not hiding the ball. They want you to be really clear about this so that they make sure that you know. And it's like, here's exactly what your offense is. Here's exactly how we calculated it. Here's the cross references to how we calculated it. Here's exactly how it came about. Here's exactly why we're dropping it for exactly these reasons. Here's exactly what your criminal history score is because of exactly these reasons, right? We're not trying to hide the ball. And then they go on to say, well, based on that, the guidelines, which are not binding on the court, incidentally, they can go up or down from there, right? Because the guidelines are just a recommendation. They're a strong recommendation, but nevertheless. But they're not hiding the ball. They say 41 to 51 months. And he was convicted and sentenced to somewhere between 41 and 51 months. So how upset can you be, man? We told you exactly what you were facing, right? We didn't hide the ball. Pursuant to this, we also estimate the fine range at between $15,000 to $150,000. And your client reserves the right not to ask them not to impose a fine. So you can ask them not to impose the fine if you want. We don't care. That's fine. The parties agree that solely for the purpose of calculating the applicable range, neither a downward nor upward departure from the guidelines set forth above is warranted, except the government reserves the right to request an upward departure pursuant to some other section of law, which isn't going to be, consistent here. But they're still telling you. Except as provided for reservation of allocution, the parties also agree that neither party will seek an offense level calculation different from this. So the government says, we are agreeing that we will not seek any offense calculation other than this. This is the only one we'll seek. However, the parties are free to argue for criminal history category different from that estimated above, which doesn't really matter because he has no criminal history, so it doesn't matter. Your client understands and acknowledges the guideline calculated above is not binding on the probation officer or the court. Sentencing is for the court. Sentencing is for the court, for the judge. The Department of Justice doesn't control sentencing. They control what charges are being brought, but they don't control sentencing. So the Department of Justice, what they can do is make recommendations. And the defense team can make recommendations. And the judge can say, I like the prosecutor's recommendations. I like the defense recommendations. I should meet somewhere in the middle. I don't like either of them. They're both too high. I don't like either of them. They're both too low. Right? Any of those options. All those options. They're both too low. They're both too high. One's right. The other one's right. Somewhere in between. Anything. They're not binding on the court. They tell you to plead your case before the judge. They are not making this shit up. Should the court or probation officer determine the guideline range is different, that will not be a basis for withdrawal. So if the guidelines are wrong because the court determines a different level, sucks to be you. Your client understands the terms of this section apply only to conduct that occurred before the execution. Should your client commit any conduct after the execution that would form the basis for an increase in your offense level or justify an upward departure, for example, but not limited to obstruction of justice, failure to appear, criminal conduct, and false statements, the government's free to seek an increase. So if you commit more crimes, we have the right to seek an upward departure, because that definitely is a thing that happens. The parties further agree sentencing within the guidelines range would constitute a reasonable sentence in light of all the factors. Should such a sentence be subject to appellate review notwithstanding the appeal waiver? So you're agreeing that this is reasonable if you appeal, despite the fact that you're not allowed to appeal. because you waived your appeal. However, the parties agree either party may seek a variance and suggest the court consider sentencing outside the guideline range based on factors. So, you can ask for sentencing beyond the guidelines, right? The U.S. government didn't even promise to recommend a sentence within the guidelines, if you take notice. They said they wouldn't contest the guideline number. They said they wouldn't contest the guideline category. They said they wouldn't contest the fact that this was offense level 22. They said they wouldn't contest the fact that this was criminal history 1. But they never at any point said, we're agreeing to recommend a sentence. They never said that. This is why it's important to read the words very carefully, like a lawyer, and what it does and does not agree to. Like, the Department of Justice agrees that these are the guidelines, but what that says is either party can seek a variance outside the guidelines, which is a thing the court can do, right? So this is the guideline penalty, but if we want to get up there and say, we don't think 41 to 50, whatever it was, is enough. We want, how about 70? And you're like, wait, what? Like, well, we agree that the sentencing guidelines are this. We just don't think they're adequate. We want 70. You can't be sad because they never promised to recommend a particular sentence. They didn't promise to recommend it. That's exactly what that says. Pay attention. The words matter, man. Okay, the government and your client reserve the right to describe fully, both orally and in writing, to the sentencing judge, the nature and seriousness of the misconduct, including any misconduct not described in the charges, for which your client is pleading guilty, to inform the pre-sentence report writer and the court of any relevant facts, to dispute any factual inaccuracies in the pre-sentencing report, and contest any matters not provided for in this agreement. The parties also reserve the right to address the correctness of any sentencing guideline calculations determined by the pre-sentencing writer or court, even if those calculations differ from those above, right? So if the guy who does the pre-sentencing report, which is an independent person that works for the judicial system, they're also going to do a pre-sentencing guideline calculation. So the Department of Justice says, well, we think it's 22-1. We're agreeing to that. But if for any reason this other guy comes up with a different number, we have the right to contest that. Not for least reasons we agreed to 22-1. So, in the event the court or the pre-sentencing writer considers any sentencing guidelines, adjustments, departure, or calculations different, or contemplates a sentence outside the range based upon factors, the parties reserve the right to answer any related inquiries from the court or the pre-sentencing writer and to allocate for a sentence within the guideline range, or as ultimately determined by the court, even if the guideline range ultimately determined by the court is different from that range. So it's like, pay attention to what you're agreeing to, man. The fine details matter. In addition, if the agreements the parties have agreed to recommend or refrain from recommending to the court any particular resolution, the parties reserve the right to full allocution in any post-sentencing litigation. The parties retain the right of full allocution in connection with any motion which may be filed in this matter before the Bureau of Prisons. Your client acknowledges the government is not obligated to and does not intend to file any post-sentencing downward departure motion. Because, we could file for post-sentencing downward departure, but we're definitely not going to do that. And then, again, we're just going to remind you of the critical details here. Make sure you're paying attention. Court not bound by this agreement or sentencing guidelines. Your client understands the sentence in this case will be imposed in accordance with the statute upon consideration of the guidelines. Your client further understands the sentence to be imposed is a matter solely within the discretion of the court. Pay attention. Your client acknowledges the court is not obligated to follow any recommendations of the government at the time of sentencing. Your client understands that neither the government's recommendation nor the sentencing guidelines are binding on the court. They sure aren't. Your client acknowledges that your client's entry of guilty plea to the charged offenses authorizes the court to impose any sentence up to and including the statutory maximum, which may be greater than the range. In this case, it'll be a lot greater than the range, but that's a possibility. The government cannot and does not make any proper promise or representation as to what sentence your client will receive. Moreover, it's understood your client will have no right to withdraw your client's plea of guilty should the court impose a sentencing that's outside the range. So you are agreeing to plead guilty, and this is the range, but if the court decides to dick you over, you are agreeing that you can't withdraw your guilty plea just because they decide to dick you over. So pay attention. The words matter on the page. The government and your client will be bound by this agreement, regardless of sentence imposed by the court. Any effort by your client to withdraw this plea of guilty because of the length of the sentence shall be constituted a breach of this agreement, which, they're in breach of the agreement. Your client agrees not to object to the government's recommendation to the court at the time of plea of guilty, that your client be detained without bond pending sentencing. And so then there's a whole bunch of waivers. Your client agrees to waives any challenge of venue. I mean, it is the appropriate venue, but just for the hell of it, let's agree to waive that anyway. The statute of limitations, this is a fun one. Your client agrees that should the conviction for the plea of guilty be vacated for any reason, any prosecution based on the set offense is not time barred by statute. It is the intent of this agreement to waive all defenses based on statute of limitations with respect to any prosecution of conduct set forth in the attachment statement of offense that's not time barred. So if, for any reason, this becomes vacated at some point in the future, you can't argue, hey, wait a second, you can't put me on trial again because that's outside the statute of limitations. No, you just waive the statute of limitations. What statute of limitations? It doesn't apply to you, ma'am. That's what you're agreeing to. Read the words on the page. Your client understands by pleading guilty, you agree to waive certain rights afforded by the Constitution and or statute or rule. Your client agrees to forego the right to any future discovery or disclosures of information not already provided at this time. Your client agrees to waive, among other rights, the right to plead not guilty and the right to a jury trial. If there was a jury trial, your client would have the right to be represented by counsel. Again, this is just to inform you of your basic rights. The judge is going to do this too. But the U.S. attorney is absolutely smart to put this in here, right? Just to remind you, these are your rights. And the judge is going to do this too. Just to remind you, these are your rights, right? So it's like, just to remind you all the things you're giving up. If there were a jury, your client would have the right to be represented by clients, to confront and cross-examine witnesses, to challenge the admissibility of evidence, to compel witnesses to appear. If there was a trial jury and your client does not choose to testify, your client would have the right to have the jury instructed that failure to testify could not be held against the client. Your client would further have the right to have the jury instructed that your client is presumed innocent until proven guilty, and the burden of proof would be on the state to prove guilt beyond a reasonable doubt. If your client was found guilty after trial, your client would have the right to appeal this conviction. You understand that the Fifth Amendment to the Constitution protects your client from the use of self-incriminating statements in a criminal prosecution. If you keep your mouth shut, sure. By entering this plea of guilty, you knowingly and voluntarily waive or give up your right against self-incrimination. You're definitely incriminating yourself because you're agreeing to all those pesky facts. Your client acknowledges discussing with you Rule 11 of the Federal Rules of Procedure and Rule 410 of the procedure, which ordinarily limit admissibility of statements made by defendant in the course of plea agreements. So that's a really big deal. That's a really big deal. So let me tell you what that says. All right. So any statements you make during the plea negotiation process cannot be used by you in court unless you take the stand, and then they can be used as character evidence. I mean, if you say something false or inconsistent, right? But if you don't bring it up, so if you say things during the course of plea negotiations, and you want a lawyer for this, right? So you can't just go, hey, prosecutor, by the way, blah blah blah, right? So there's parameters. But anything you say during those plea negotiations can't be used against you in court. If you say something completely inconsistent with that on the stand, then they can challenge your credibility. But if you never say anything inconsistent, whether you repeat that stuff or not, right? They can't bring it up. So during cross-examination, they can't bring it up. Anything they learned from that process. So if they learned it from somewhere else, they can ask you about it. Right? But if the only way they had that knowledge was from that plea negotiation, they can't bring it up. Negotiation conferences are secret. They're privileged, if you like. Privileged is not quite the right word, but they're confidential. They can't be used against you. So that's what that says. Hey, you might have made a whole bunch of representations, to us during the plea negotiation process. If in the end of the day you tell us to buzz off, there are rules, man. We can't use that shit against you. Okay? So you acknowledge discussing this rule, which ordinarily limits the admissibility of statements that are made in the course of those plea negotiations. Your client knowingly and voluntarily waives right that arise from this rule in the event your client later withdraws the plea of guilty or withdrawals from this agreement. So one of the things we're agreeing to is, hey, wait a second, there's a rule that says specifically we can't use this against you in trial, but we're making a plea agreement, so we can agree to pretty much anything, right? So one of the things you're agreeing to is if you told us anything during those plea negotiation conferences, and you attempt to withdraw or you attempt to modify this, now we're able to bring all that back in. Now we're able to bring it back in. So you're agreeing to waive that if you try to withdraw. So to the extent you said anything that would further damn you, we can bring that up. You also agree to waive all constitutional rights to a speedy sentence, which is not really a right, but whatever. And it agrees to a plea of guilty pursuant to this agreement will be entered at a time decided upon the parties with concurrence of the court. You understand the date for sentencing will be determined by the court. Is it uncommon to use parallel construction to get that information? Well, probably not. Probably not, but you have to be very careful about how you do that so you don't get burned. But yeah, once you know, you might be able to put it together, but you have to be very, very careful about that. So just, yeah, you might, yeah. But as I say, it doesn't apply to anything you learned otherwise. So if they come and tell you everything if they come and tell you nothing new, right? So it doesn't matter, right? So it only matters if they tell you something new. So your client agrees to waive insofar as waivers permitted the right to appeal. So you're agreeing to waive appeal. Included but not limited to the claims that the statute to which your client is pleading is unconstitutional. Can't argue that. The admitted conduct does not fall within the scope of the statute. Can't argue that. Your client understands federal law affords the defendant the right to appeal their sentence in certain circumstances. Your client agrees to waive the right to appeal the sentence, including but not limited to any term of imprisonment, fine, forfeiture, award of restitution, term or condition of a release, authority of the court to set release, and any manner in which the sentence was determined, except to the extent your court sentences you above the statutory guidelines, or except to the extent the court sentences you above the statutory maximum, or above the guidelines range determined by the court. So if they go above the guidelines range, you don't have the right to withdraw your plea of guilty, but you can appeal the sentence. So, and you obviously can appeal if they sentence you to more than the statute allows, because obviously they can't do that. Realizing the uncertainty in which estimating the sentence will ultimately impose, your client knowingly and willingly waives the right to appeal the sentence to the extent noted above in exchange for concessions made by the government. Notwithstanding the above agreement, your client retains the right to appeal on the basis of ineffective assistance of counsel, but not to raise other issues regarding conviction sentence. So that's basically your only track left, and probably the track that Pierce is going for, right? It's you don't waive, that would be a little bit hard to waive the ineffective assistance of counsel, because it's the counsel themselves that would be reading and signing this off. So if they're ineffective, you don't agree to that. But let me just tell you, ineffective assistance of counsel is really hard. As I'm sure we've discussed on the channel before, that's a really hard thing. You basically have to show that this guy is truly incompetent. And that's really, really hard. That's really, really hard to show this lawyer is truly incompetent or did something that no reasonable lawyer would do. And lawyers get a lot of latitude for doing stuff because there are tactical and strategic concerns. So a lawyer might do something that might make another lawyer scratch their head, but from within their own frame of reference makes sense because of various tactical considerations. Those tactical considerations may or may not pan out at the end of the day, which is one of the reasons that it makes the other lawyers scratch their head, because we're we're not so sure about that one. And then it doesn't pan out. But yeah, you get a lot of latitude as a lawyer. So you have to do something basically no other reasonable attorney would do. You have to fail to look at particular lines of defense, or, blatantly ignore, stuff. It's pretty damn hard. So if you're going to appeal on ineffective assistance of counsel, all I can say is Godspeed, sir, because that's probably not going to end up well. Your client also agrees to waive any challenge to the conviction imposed by the agreement or otherwise attempt to modify the agreement in which by collateral attack, including by admission to habeas, except to the extent of motions based on newly discovered evidence or on a claim your client received ineffective assistance counsel. Your client reserves the right to file a motion brought by 3582, but waives the right to appeal for denial of that motion. The government agrees pursuant to law that the self-incriminating information provided by your client pursuant to this agreement during the course of the debriefings in anticipation of the agreement and about which the government had no prior knowledge or insufficient proof in the absence of admission will not be used by the government at the time of sentencing. So any statements you made during the plea negotiations, we won't use against you, but it may be used for purposes in accordance with terms as we've noted above. Client, your restitution, client acknowledges a riot occurred, caused approximately $1,495,326.55 of damage. Your client agrees to a part of the deal to pay restitution in the amount of $2,000. Payment shall be made to the court in order to facilitate collection, blah, 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 blah. Your client understands that after entering this agreement, your client fails to perform any of it. That's breach. In the event of the breach, government will be free from its obligations. Your client will not have the right to withdraw the guilty plea. Your client will be subject to full criminal prosecution for any other crimes, including perjury and obstruction. Government will be free to use against your client directly and indirectly in any civil or criminal proceeding all statements made by your client and any information or materials received by your client, including such statement, information, materials provided pursuant to this agreement or during any course of debriefing. That's all the things, basically, whether or not any debriefings were previously characterized as off the record. So, if you breach this agreement, all that goes bye-bye. Your client understands government shall be required to prove breach only by preponderance of the evidence. So only by 51%, because remember, a plea negotiation is a contract. Remember, I think I told you that earlier, right? A plea negotiation is a contract. It's just a special kind of contract. It's a special kind of contract. And so contracts are typically, the civil standard. It's the civil standard for contracts, right? 51%. So it's no different here. Like, the government only has to prove breach by 51%, not beyond a reasonable doubt, because we're basically interpreting it using the civil standard because it's a contract like any other contract. It's just for special and unique things. Nothing in this agreement shall be constituted to permit your client to commit perjury, to make false statement or declarations, to obstruct justice, or protect your client from prosecution for any crimes not included with the agreement or committed after execution. You'll understand the government reserves the right to prosecute your client for such offenses. You further understand that any perjury, false statement, obstruction relating to obligations shall be constituted a breach. In the event of the breach, your client will not be allowed to withdraw. And then this is the other major part. This is the other major part of basically every contract. Every contract has a provision like this, and plea agreements are no exception. So this is the part like you really want to pay attention to, and you want to really make sure you understand all these words, right? This is an important part of contracts. Complete agreement. Complete agreement. No agreements, promises, understandings, or representations have been made by the parties or their counsel other than those contained in the writing herein. Nor will any such agreements, promises, understandings, or representations be made unless committed to writing and signed by your client, defense counsel, and the assistant attorney general. So that's the big deal, right? So pay close attention. If it's not within the four corners of this document, it does not exist. You cannot go and say, hey, wait a second, you said this at that meeting, or you said that at this meeting, or you made this promise, or the detective made that promise, or whatever, right? You said this, or my clients or my lawyer said that. No, everything's in this document. If it is not in the document, it does not exist. That's what it means by a complete agreement. All that exists is this contract, nothing more. There is nothing outside the contract. It does not exist. If it's not here, it doesn't exist. So all those other promises, to the extent they exist, poof. Because that's what complete agreement means, man. Everything is here. Your client further understands this agreement is binding only upon the criminal and superior court divisions of the United States Attorney for the District of Columbia. This agreement does not bind the civil division of this office, so we can sue you, or any other United States Attorney's office. So if there's somehow some other prosecution that could be made by some other attorney's office, it doesn't bind them, nor does it bind any state, local, or federal prosecutor. So to the extent that, you know, a state or locality, which isn't applicable here because DC is federal, so this doesn't really apply, but, you know, still. It also doesn't bar or comprise any civil, tax, or administrative claim. So if there's those and the foregoing are compliant, then you can sign by the Assistant Attorney General, or signed by the Assistant Attorney, signed by the Assistant Attorney, and defendant's acceptance. I've read every page of this agreement and discussed it with my attorney, Albert Watkins. I fully understand this agreement and agree to it without reservation. I do this voluntarily and of my own free will, intending to be legally bound. No threats have been made to me, nor am I under the influence of anything that could impede my ability to understand this agreement fully. I am pleading guilty because I am, in fact, guilty of the offenses identified in this agreement. I reaffirm that absolutely no promises, agreements, understandings, or conditions have been made or entered into connection with my decision to plead guilty except those set forth. There is nothing more, only this. I am satisfied with the legal services provided by my attorney. I am satisfied with the legal services provided by my attorney. Yeah. In connection with this agreement and matters related to it. So at least at the date I signed this, I was totally satisfied. Now I'm less satisfied. And then the attorney acknowledges that I've discussed it and, you know, concur in the blah, 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 whatever. So yeah, that's a lot of stuff, man. That's a lot of stuff. So yeah, the long and short of it is that the overwhelming odds are that shaman guy is going to be spending some quality time in a federal prison for the next 3 years and change. So, yeah. I mean, I thought it was worth the time. I thought it was worth the time to go through one of these things in detail and explain it in detail so you can see exactly how one of these are written. Now, again, different agreements have different provisions. So not every one of these is identical, but the major themes of it certainly are. Like, if you read this, you would recognize this in lots of other contracts despite different terms. So I thought maybe it'd be helpful for you to see what a plea agreement looks like. I thought it might be helpful for you to see what a signed proffer looks like. What are you agreeing to? What facts are you agreeing to? What are you agreeing to waive? What are you agreeing to sentence? What are you agreeing to give up? What are they agreeing to give up? And so forth and so on. So I hope, you know, yeah, the signed by date and the no later than date are different. Let's see. Well, first of all, is that 1 September? I guess it is 1 September that this is signed, 2021. And it was supposed to be agreed to. Yeah, August 18th. So I guess, or August 13th. So I can't say for sure what happened, right? You know, but I can't say what happened, but maybe they asked for more time. Maybe they asked for more time, right? I mean, it was signed off by the U.S. Attorney. It was signed off by the U.S. Attorney. It was filed by the U.S. Attorney, so the U.S. Attorney is happy with it. So maybe they gave him an additional 2 weeks. I mean, whatever. So yeah, the date is after the day of the agreement, but as long as they agree to it, it's like, well, the agreement's still valid. Shouldn't be a problem. So, but, you know, nice. Oh, no time off for good behavior. As a matter of fact, you do get time off for good behavior. I believe the federal rule is it 75% or 80% of your sentence? Or is it 85%? It's something like that. So in the federal system, you get good time credit. So as long as you are behaving in jail, you effectively only have to serve 75, 80, 85%. It's one of those numbers. It's defined in the statute. But yes, you do get time off for good behavior. So yeah, that's definitely a thing in the federal system too. So I thought that'd be good. I thought that'd be helpful. Okay, I might cut that up and release it separately because that's a lot of story. Or maybe not, but we'll see. We'll see. All right, so let's finish off with just a really quick one. That was by far and away the long story of the day. Are pleas over open negotiation? Sure. Yeah, pleas are open negotiation. What they will or will not waive is a matter for the parties. But yeah, pleas are open negotiation. How much they're willing to negotiate is, you know, an entirely separate matter. But yeah, they're open negotiation. You know, yeah, they're open negotiation. Can they forcibly vaccinate you in federal prison? I honestly don't know. I'm going to go with yes, probably. All right, let's move on to the last story. Then this is a little bit more fun. All right, so this is from my former home of South Carolina, where I grew up and spent the early part of my life in South Carolina. So there's an attorney named Alex Murdaugh. He's a very famous attorney in Low Country, South Carolina, and he kind of ran Low Country, South Carolina, to be quite honest, for a while as an attorney. And as you can see, things have not gone so well for Alex Murdaugh over the years, or recently. He's kind of not going super well. Currently facing, he's facing 27 new criminal charges on top of the stuff he was already doing. So these indictments include breach of trust, obtaining property by false pretenses, money laundering, computer crime, and forgery from several South Carolinas that span the course of several years. Because, as I mentioned, you know. And then, of course, we have indictments for 4 counts of breach of trust with fraud intent, 7 counts of obtaining signature or property by false pretense, 7 counts of money laundering, 8 counts of computer crimes, 1 count of forgery. We got Bramberg County, Orangeburg County, Colton County, Beaufort County, Allendale County. You know, it's not going super great for our friend here in terms of what's going on in terms of these various things. So yeah, here's some indictment now, just all these trusts and all this stuff. So yeah, so I just wanted to lay that out for you to show you some of the things that he's been trusted with as a way of background. So that's just a background article to let you know a little bit about who Alex Murdaugh is. It's not going well. Former king of lawyers in Low Country, South Carolina, and not so much. But now let's talk a little bit about some fuckery that's going on in this case. Now, you know, a little bit about Murdaugh. So Murdaugh's attorney files a complaint with the disciplinary group after Satterfield's remarks. Really? We're doing this now? We're really going to start filing bar complaints against other attorneys that are opposing us in actions while the actions are ongoing? That is such a dick move. That might be the dickest move you can possibly do. That might be the singular dickish thing you can do, man. To file a complaint against another attorney while you're also ongoing in the case. It's like, you know, if you want to wait till after the case and complain about stuff, I guess. But, you know, it's a dick-ass move to do it in the middle of proceedings. But that's not stopping the guy representing Murdaugh. Let's throw some mud around because it's not going so well for my client. So his Murdaugh, who's a dick, quite literally, has filed a complaint with the state lawyers disciplinary board against Eric Bland, the attorney who represents the estate of Murdaugh's deceased housekeeper, for comments he's made in the media organizations. Really? We're going after the attorney representing the estate of the deceased housekeeper who your client probably killed? Probably killed. He files these allegations against them, seeking a gag order too. And Bland says he's not going to give up his right as a lawyer to speak counterly to counter what's going on. Man, this is such a dick-ass move. It's unbelievable how cheesy this thing is. You know, let's read a little bit more about this fuckery over here. Murdaugh's lawyers seek sanctions against Satterfield attorney. Attorneys for the suspended lawyer are asking a judge to sanction attorney representing the estate of Murdaugh's deceased former housekeeper for comments he made to news organizations in an emergency motion. The motion asks the judge to impose a gag order. The motion asks that Bland be referred to the ethics board. Bland has sued Murdaugh for $3.5 million in settlement money intended for Satterfield. So this is money she should have already gotten. Remember, she's suing her own lawyer, right? She's suing her own lawyer. So this is Girardi. This is Girardi. Girardi and Murdaugh are twins. You know? She's suing for $3.5 million in settlement money she already was supposed to get. But she didn't receive that. And he's facing many criminal charges for illegal diversion. Okay. He thinks the comments are intended to taint the pool of jurors against his client. Uh-huh. They highlight comments from Bland that allege Murdaugh committed many of the crimes and say Bland implicitly accused Murdaugh of murdering. Yeah, that does seem to be a thing. There is quite a lot of death of quite a lot of people in and around Murdaugh. It's a little suspicioso, a little more suspicious. He hasn't been charged with any of the murders yet. But, you know, there are quite a few people who have died surrounding this guy in suspicious circumstances. So in addition to the fraud and the money laundering and the false signatures and the computer fraud and the embezzlement and keeping money away from your own clients and so forth and so on, yeah, it's somewhat likely he's a multiple murderer too. Things in the Low Country are getting real. So yeah, that's what's happening there. So it's a whole bunch of fuckery, as Emily D. Baker would say. So that's what's going on. So those are the stories I have for you tonight. A panoply of stories. Talked about 4 things. Spent a lot of time on Shaman Guy, which was our legal education portion of the day. So I hope you enjoyed legal education portion of the day with Shaman Guy. And then we had some just fun stories where we're shitting over people because we can. And all that good stuff. So in terms of the Ghislaine Maxwell trial, or Ghislaine, or however we're pronouncing her damn name, in terms of her trial, I'm still trying to figure out how to cover it, to be quite honest. The problem is there's no transcript, there's no audio, there's no nothing. And so, I mean, I got very little to work with. But I'll probably do something on tomorrow after I talk with Stephanie a little bit about how we can cover it effectively, because I know people are interested in my opinion and stuff. My short opinion is that she's very, very dirty and whatever. What did Javier do? Karen Mon? Oh, no, that's not good at all. No, that's not good at all. She is, first of all, she's chief mod. She's head mod. So, you know, don't anger Stephanie. Because she's head mod for a reason. She helps me out on this channel a lot. And she gives me good advice. And it's prudent to remember that she's giving me good advice because, you know, she helps the channel be better. So, also, she's only enforcing the rules I told her to enforce. Because I'm still owner of the channel. So she might be head mod, but I'm owner of the channel. And so she's only enforcing the rules I told her to enforce. Because, you know, it's my channel. And that's what I told her to do. So, you know, she's doing that. I'm not sure how this is hard to contemplate, man. Don't be a dick to anything. So, yeah. So let's see if there's any super chats that came in, acknowledge the super chats, and maybe read a couple of the messages that might have come in across the way. I mean, we do have a rule to be vaguely on topic. I mean, that is a rule. She is quite right. Let's see what's going on in Pacer, this Maxwell trial. Letters addressed to the judge. There's letters from Maxwell addressed to the judge, addressed to all kinds of people. Oh my God. What a mess. We won't get transcripts for like 3 months, and they'll be redacted too, I'm sure. Let's do a couple super chats. $4.99 from Johnny F. Face. Is a Subway sandwich location open at 2 a.m.? They can be. Some of them have 24 hours. $20 from Caleb S. I'm a CPA in my mid-40s and mid-career in an executive finance role, doing well. Always been interested in law, something like Concord Law, a CPA-only online school is my only option. What are your thoughts? They are not ABA certified, is my thoughts. Yeah, they're only California bar. So, I mean, if you want to be, okay, my thoughts in general against California only schools is that they're trash. That is my opinion, if you want my opinion. California, for some reason that I don't fully understand, has a bunch of schools that are only valid for California. So if you ever want to work anywhere else, they're not valid. And second of all, a lot of them are just trash garbage. They're not good in their education. To be ABA certified means you have to meet a basic minimum level of confidence, which even they can't meet. So my recommendation would have to be against going to the CBA only school, online school. It's probably not a good idea, all things being considered. $5 from Mandrake. Hey, UL, thanks for stream. Going to hang back and knock out. Have a great night. And $2 says, who's the plea deal for? For shaman guy. That's who the plea deal was for. Yeah, I know Good Logic went to the courthouse. I'm trying to figure out how to do my own coverage. Yeah, I know Good Logic went to the thing. I'm trying to figure out what coverage I want to do. Salty says, do they give you plea deals in federal cases? Oh yeah, all the time. What's a special assessment and how that's different from a fine? It's just a fine. It's just an amount you owe no matter what. I don't know what it is or where it comes from, but it's $100. I don't know. What do I think of some of the challenges to the 1512 charges? I mean, I understand some of them are trying to say, well, how do you prove corruptly? But for me, I don't think it's that hard. So maybe I'm missing something. Joe said, will you ever cover the H3 podcast lawsuits? I've done it a little bit in the past, but maybe I'll do more of it. Will QAnon shaman appeal to DC judges, making more hesitant to believe defendants are remorseful? The shaman guy being so eccentric in his dress and outspoken demeanor add to his sentencing? Was he escalating the crowd? He did escalate the crowd with the bullhorn and stuff, so yeah. Does a prosecutor's absolute immunity protect from CP charges in the Duggar case? What about the jury? Yes. Yes, it does. It does protect them because it's evidence. It's evidence. So yes, it is admissible, and they are not guilty of possession, or they're not guilty of any crimes related to CP if they're using it within the scope of their official duties. And there are a lot of people who, I don't know if a lot of people, but there are people who specialize specifically in that. For like example, for like the FBI. I mean, that's got to be like the worst job ever. I mean, how tough a job is that for the FBI, man? If you're the guy who gets assigned to scour the web in the very dark and seedy places and find the CP so it can be flagged, that's got to be a rough gig, man. Any law schools I do recommend? Well, an ABA certified one would be great. Michael says, hi, Kurt. I tuned in last night as you were ending the show and I sent $20 super chat with a question. Did I happen to see it after? Well, I could go back into analytics and try to find it. Let me see. This will take a second. Talk amongst yourselves. Talk amongst yourselves while I'm trying to figure out where this is on the back end of my things. So, oh, by the way, I don't know how much of you tuned in to the taser cop trial today. That judge, man, that judge is putting me to sleep big time. I thought I was going to pass out. It's ASMR judge. Huge. It's ASMR judge. It is really, 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 really tiring and stuff. Let's see. I believe this is the comment. Yes, it is. From Michael Palmer yesterday. Hi, Kurt. I know you said you'd review cases for a $25 super chat. Could you possibly consider looking at a crooked case that has a lot of video to give an opinion as to what went so wrong? Well, when you ask me to look at a case, that's asking for actually quite a lot. That's asking for a lot more than me just to review an opinion. When I review an opinion, I have an opinion. I have a singular document that I'm looking at that has been compiled by the court and has everything I need in it, and I can comment on it. When you ask me to look at a case, you're potentially asking me to do quite a lot more legwork than that. You're asking me to, first of all, I'd have to watch the video. Then I have to determine if anything has gone corrupt. And then if it has, determine why. And that's a lot more analysis than simply reading a document. You're asking me to try to actually dig into something and find out why something has gone wrong. That's got to be quite a few things on top of itself. So you're asking for a lot. He's willing to pay more. We'll have to Stephanie and I'll have to talk about what's a reasonable rate, to be quite honest. So yeah, email us with details and we'll talk. But I mean, you're asking for a lot, and potentially, like, I don't even know how much. So it's a big ask. What is supervised release versus parole? Nothing in particular. They're the same thing. Well, I'll tell you what the difference is in the federal system. There is no parole in the federal system. Well, so that's the big difference in the federal government. There's no such thing as parole in the federal government. There's no such thing as parole in the federal government. So supervised release is different from parole because there's no such thing as parole. You get good time credit if you're behaving, but that's the only way you get out earlier. There's no parole in the federal system. But after your sentencing is over, there might be a period of supervised release on top of that. So that's how it's different from parole. In the GDP case, Amberlynn, one of the female conspirators, who would be the reference, had charges dropped against her without prejudice, and there hasn't been a plea deal. Okay, well, that happens sometimes too. Plea deals, sometimes charges are dropped. If fines and penalties are prescribed by federal law, why does one need an attorney? To represent your interests and potentially advocate for you and find mitigating factors and try to attack the state's case. And also, he's being charged with quite a few more things on top of that. So he got quite a few things dismissed. So there's lots of reason to have an attorney. Did you end up falling asleep during the latter part of the jury selection? I thought about it. I never knew Murdaugh back then. I did not know it. No, Girardi didn't commit homicide. That might be a distinction. Have I heard anything about the January 6th prisoners being treated badly, in some cases tortured? I've heard nothing like that. I assume that prison has not been nice, but I've heard nothing like that personally. All right. So that's, $400 an hour, says King of Casuals. Maybe. Probably not that much, but we have to negotiate. Okay, anyways, guys, I'm going to sign off for tonight. I hope you found this tonight. Everyone, thanks Stephanie for being such a great mod, helping me behind the scenes. She's helping me with YouTube and yelling at them for me, which is appreciated. She created this thumbnail. She found these stories today, and she suggested them and, helped prep me to get me ready. And she's got a whole lot more stories. She gave me so many stories. I was like, you got to stop. She said, but you said you asked me for stories. I'm like, well, now I'm telling you to triage the stories, man. It's just too much. But she's been really, really great behind the scenes helping this channel grow. And it's and she deserves a lot of credit as a result. So, as always, thanks to her. Where are we today in terms of the channel? Let's see what our current numbers are. As of right now, we're at 43,733. Well, we could be at 44,000. Do you know how? By hitting the subscribe button. I missed one? I missed the super chat, or I just missed a regular chat? Because sometimes I skip the regular chats. The regular chats are not guaranteed. So sometimes I skip them. I try to read all the super chats, though. Anyways, we could be at 44,000. If you would subscribe. So if you haven't done so, would you please hit the subscribe button? See if we can maybe get to 50,000 by the end of the year. That'd be great. If you haven't liked this stream already, please remember to like it. YouTube really likes the engagement, And they really like it when you like the things because they'll recommend it and stuff and things like that. I know it's a little lame, but you know, whatever. And if you're subscribed, don't forget to hit the bell. And also you can check Twitter and stuff because that's also where a lot of my videos get announced. So there's that. There was a super chat I missed. $5 from, it came in later. I see. It came in after I stopped reading them. I see why. $5 from Ann Feinstein. Fictional manuscript question. Location. Oklahoma man records the audio of his ex-wife in his home while picking up the kids. Is he in legal trouble? Is Oklahoma a one-party consent state or not? Well, let's find out. And it's also in a place that's private. And he's recording his audio of his wife. Let's see what status is in Oklahoma. Hold on while I do some research behind the scenes. Okay, Oklahoma is a one-party consent state. So you don't need the other person's consent. So it should be fine. It should be fine in Oklahoma. So that is my tentative, but in no way legal advice answer to that question. So yeah. So I'm going to sign off for now. Please remember to do the YouTube-y things. And as always, it's been a pleasure. Until later, my friends, cheers and goodbye.